Hello and welcome to this extra special report of week 3 of the Trump trial. Let's dive right in, shall we? I feel like we have a lot to cover. First, however, I wanted to lay out a little timeline for you so we can situate ourselves in where we're at in this trial. If you want a timeline of the actual background of this trial, check out my recap of week 1. I give a whole background on what the hell is going on. I'm not going to bore you with that now. Go check that out after you watch this. But just so that we know the direction we're headed in. Week 1 started with jury selection. Week 2 then started with opening arguments and moved into the prosecution's case, wherein they're calling all of their witnesses to present their evidence, all right? And that's where we're at right now, and we're going to continue there probably for a few weeks. Then the prosecution will rest. The defense will then have the opportunity to present its case. It can present nothing. It can present its own witnesses. Trump has said he's going to testify. A lot of people are saying that might be a bad idea, but he might do it anyway. Then the prosecution will have an opportunity for rebuttal. Then both sides will give their closing arguments where they'll be able to say to the jury, you've seen all the evidence. Let me string it all together for you so it's really clear what we're saying. Please find in my favor. And then the jury will receive their instructions and it will be up to them to deliberate. So again, we are just in the prosecution's witnesses right now, but that's the direction that we're heading in, okay? We all situated? Great. One other timeline I wanted to present to you, just so that we are situated around the 2016 election. I think this is important to understand, especially with this week's testimony that I'm going to go over with you, is the month leading up to the November 8th, 2016 presidential election. We have the Access Hollywood tape, which drops October 6th, 2016, so a month before that election. That's the tape where you can hear Trump saying that he grabs him by the pussy. That's that Access Hollywood tape. And this sends the Trump campaign into a bit of overdrive because there was a lot of like back-to-back media coverage once that tape dropped. And then within the next month, Stormy Daniels received her payment for her story. She got paid off for that story. And then there was the Karen McDougal leak November 4th, 4 days before the election, in which a story was published by the Wall Street Journal saying that Karen McDougal was paid off by the Trump campaign for her story, and also mentioning the Stormy Daniels story as well. So this kind of happened back to back, and it helps to build the timeline around the lead up to the election and how the campaign saw these stories and was reacting to these stories in real time as they were coming out. Again, because the prosecution's trying to show this was a scheme to affect the campaign and the outcome of the 2016 election, okay? So just so we're really clear on that timeline, great. Let's get into what happened this week. Monday, well, actually, let's go over what happened at the end of last week before we get into what happened on Monday. So we wrapped up on Friday last week with David Pecker, the former CEO of American Media, on cross-exam and redirect. And on redirect, the prosecution made clear that the agreement that American Media signed with Karen McDougal was meant merely as a cover-up to keep her from sharing her story about her affair with Donald Trump, and it was meant to affect the outcome of the 2016 election. And he read from his and American Media's non-prosecution agreement, in which he explicitly agreed that Karen McDougal, the agreement was meant to cover up what was essentially an illegal campaign contribution meant to affect the outcome of the 2016 election. And it's really important that the jury was left with that impression when David Pecker left the stand, because on cross-exam, the defense tried to make it seem like the National Enquirer was just in the business of paying off people for their stories, and this was nothing different. But on redirect, the prosecution was able to say, no, this was different. This was not like the other stories the National Enquirer bought. This had an illegal purpose, and everyone involved knew that. At least that's what the state is alleging. Then on Friday, we had Rona Graff. She took the stand and confirmed that both Karen McDougal and Stormy Daniels were in Trump's personal contacts that she, Rona Graff, maintained as part of her work as his personal assistant. Then we had Gary Farrow, who took the stand. He was a banker at the bank where Michael Cohen allegedly created that LLC that he allegedly used to allegedly pay off Stormy Daniels, okay? So Farrow was really there as a custodian of records, meaning he could testify that the records were correct, and that allows the prosecution to put them before the jury and enter them into evidence. So that's where we ended on Friday of last week, okay? Then Monday this week, there was no court in session. So the next trial day after Friday was Tuesday. And so that's where we're at now. On Tuesday morning, Judge Marchand issued a written ruling regarding the 10 counts of contempt of court that the prosecution had charged Trump with for violating the gag order that Judge Marchand had imposed, which bars Trump from making public comments about witnesses and jurors so that Trump can't harass or intimidate said witnesses and jurors. And the judge found Trump guilty of contempt in 9 of those 10 allegations. One central question was whether it was a violation of the gag order for Trump to just repost something, because that's what he was doing. He was posting shit on Truth Social. He was making thoughtless statements to reporters. That's how these violations came up. And the judge said that, yes, a repost can still violate the gag order because it is showing Trump's endorsement of a message. And the judge used Trump's own words against him, saying even he, Trump, has bragged multiple times about how many people he reaches on social media, that when he posts something, millions and millions of people see it immediately. So a repost still counts against that gag order. And the judge fined Trump $9,000, but basically said he wished he could fine him more money than that. He is barred to just $1,000 per count. 9 counts total, $9,000. He wished he could fine Trump more because Trump's wealthy, so $9,000 is barely a slap on the wrist. And he said that jail time would be on the table if future violations are found so that he could properly punish Trump to help deter the behavior. However, the judge also made clear that this gag order does not give the witnesses, especially Michael Cohen and Stormy Daniels, the right to poke Trump and attack him online since he's not allowed to respond. The judge said that if he found that there were witnesses basically poking the bear, using the gag order as a sword rather than a shield, he would basically remove it as a protection for that witness, giving Trump more or less free rein to say what he wants about them. So it was a slap on the wrist for Trump, but the judge did exercise restraint and could have gone way further if he wanted to, and that's good because it helps work against the constant complaints that Trump has that the judge is biased against him. This judge is bending over backwards to make sure it is very clear that he is being as fair as possible, and that's good. A notable appearance was made in the audience at the trial on Tuesday by Texas Attorney General Ken Paxton, who sat right in the first row directly behind the defense table, which is such a fucking joke. Like, Trump will cry all day about bias against him, and then Democrats and people who generally respect the Constitution and the functioning of democracy try so hard to do nothing that might be construed as improper or biased in any way, and then Trump and all of his people don't give a flying fuck about appearing impartial and unbiased. A state attorney general attending the criminal trial of a presidential candidate and declaring, "I stand with Trump," while doing so. I mean, I'd say it's unprecedented, but like nothing about any of this is precedented, I guess. And then Trump's son, Eric, was also in attendance on Tuesday, and he was the first family member to make an appearance at the trial. So the trial continued Tuesday morning with Gary Farrow, that same banker, on the stand. He testified that Michael Cohen listed that this LLC that he created to allegedly pay off Stormy Daniels would be used for real estate consulting, and did not make any indication that the money would be used to pay off someone, especially not an adult film star, or as part of an election scheme, which would have elicited further questions from the bank had Cohen been honest with them, because typically speaking, banks generally try, at least in theory, not to be used in furtherance of a crime. And if Cohen had answered the bank's questions truthfully, Gary Farrow testified that that would have delayed or completely barred him from opening an account, but as it was, the account was opened very quickly, according to Farrow's testimony. Farrow testified that within 1 day after opening the account for Essential Consultants, LLC, the real estate consulting company, wink, wink, Michael Cohen had funded the account with $130,000 from his own home equity loan and wired it to Keith Davidson, who was Stormy Daniels' lawyer at the time. This was on October 26, 2016, and the election happened less than 2 weeks later. After a brief mid-morning recess, the prosecution called its next witness, but not before a massive email blast was sent out by the Trump campaign titled, "Democrat judge just ruled against me," and saying, "A Democrat judge just held me in contempt of court. They want to silence me," and then asking supporters to stand with Trump by contributing money. So he continues to use this witch hunt to make as much money as humanly possible. The next witness to take the stand was Dr. Robert Browning, the executive director of C-SPAN Archives, who manages C-SPAN's video collection and was called to verify the authenticity of video of a Trump campaign event. Again, in order to get these things in front of the jury and into evidence, prosecutors have to call people with knowledge of the records in order to verify their authenticity, and these are standard procedural rules. And this meant that the courtroom got to see various videos of Trump through the years, mainly clips of Trump on the campaign trail in the final weeks of his 2016 campaign, in which he denied allegations by several women after his grab 'em by the pussy video leaked. Another clip showed Trump praising Cohen as a good lawyer and a friend. Warm and fuzzy. And that's about it. Then Browning was dismissed from the witness stand with no cross-examination from the defense. And these pieces of evidence, while not smoking gun admissions of wrongdoing, are being used by the prosecution to build, brick by brick, a solid story around Trump's tactics of denial and obfuscating the truth about his interactions with women in order to protect his reputation and win the election. He did it on the campaign trail, and it also undermines any argument that Trump and Cohen weren't close confidants around the same time as the Stormy Daniels payoff. So these all add up to paint a picture for the jury piece by piece. Next on the witness stand was another custodian of records, Philip Thompson, who worked for the stenography company that took the transcripts of a deposition Trump gave in another case. Again, to get the transcript entered into evidence, they needed to call someone who can confirm its authenticity. Specifically, this transcript was of the deposition related to the 𝗬𝗥𝗧𝗏 federal defamation lawsuit against Trump. And the excerpts included Trump confirming the dates of his marriage to his wife Melania, which is a minor detail, but a fact that the prosecution nonetheless wants to confirm with the evidence to further the argument that he was cheating on his wife when he had these alleged affairs. In the transcript, Trump also confirms that he is the voice in that Access Hollywood grab 'em by the pussy tape. After brief questioning, Thompson stepped down. Prosecution then calls Keith Davidson to the stand. He was the lawyer who represented both Karen McDougal and Stormy Daniels in their hush money allegations, and he has a track record of representing people trying to sell celebrity sex tapes or other embarrassing information. So there you go, kids. Go to law school. You can become anything. Hell, I did it. Now I'm a YouTuber. So there you go. Anyway, along with Davidson's testimony came a bunch of evidence of text exchanges. The prosecution introduced a text from 2016 in which Davidson reached out to Dylan Howard, then the editor-in-chief of the National Enquirer, saying he had a blockbuster Trump story, to which Howard replied, "I will get you more than anyone for it, you know why," indicating that it was known that Trump was paying off through the National Enquirer anyone who came forward with a story. Davidson said that he didn't know what this meant, but he was aware that David Pecker, Howard's boss, was longtime friends with Trump. Davidson goes on to testify he was helping Karen McDougal shop around to sell her Trump story earlier in 2016. And he said that, interestingly, at one point during the negotiations over the final contract between Karen McDougal and the National Enquirer, Davidson, was pushed by the National Enquirer to call Michael Cohen directly, which he had been trying to avoid because, according to Davidson, Michael Cohen was not a pleasant guy and nobody really liked him. And getting this testimony from Davidson that Michael Cohen is an unlikable guy is actually good prosecution strategy. Michael Cohen is their star witness, yes, but he also comes with a ton of baggage, perjury, etc. And he's generally not a pleasant person, and that's kind of widely known. So it's priming the jury by both saying, hey, yeah, this guy is not likable. We acknowledge that. But also, here is all this evidence and all of this witness testimony ahead of Michael Cohen, so that when he takes the stand, the jury will hopefully say, okay, I don't like this guy at all, but I believe him. So they're just prepping the jury for that eventuality and acknowledging this guy's not likable, but he's telling the truth here. So once this deal was finally reached, again, Karen McDougal received $150,000 and got some pieces published in exchange for her silence. Davidson testified that he called Cohen as a professional courtesy because he knew his client was the subject of the agreement. And this is important because Trump was not a named party to the tabloid's agreement with McDougal. This was between American media and McDougal, but her lawyer knew who was the real beneficiary, Trump. and called his lawyer to confirm the deal. Under further questioning, Davidson confirmed that burying McDougal's claims with this deal would be valuable to Trump's campaign, and he knew that. Again, they're just adding to the building blocks, confirming that this was all done not just as a passive, run-of-the-mill hush money scheme, but in furtherance of a plot to affect the outcome of the 2016 presidential election. Moving forward to his representation of Stormy Daniels, Davidson testified that Daniels had been trying to shop around her story of her affair with Donald Trump earlier in 2016, but there actually wasn't much interest until that Access Hollywood Grab 'em by the Pussy tape dropped. Again, remember, it was in early October when that dropped, late October when Daniels got her money, and Davidson testified that him and Stormy both knew that this was their moment of leverage. Between the drop of the Access Hollywood tape and the election, there was going to be a lot of money to be made in selling her story. They had leverage now. It increased the value of her story. And Daniels eventually reached a deal with the National Enquirer for $120,000, but then Davidson testified that the publication backed out of the deal, telling Stormy's people to call Michael Cohen directly if she wants any hush money. And this corroborates David Pecker's testimony from earlier. Remember him? He was the CEO of American Media. He said that after paying off the doorman for $30,000, Karen McDougal for $150,000, and getting no money paid back from Trump, he had it with being Trump's bank account and told him to pay his own hush money. So it's corroborating previous witness testimony. Davidson then testified that this was the only time in his entire career of trying to help people sell their salacious stories that the National Enquirer had ever told him to deal directly with a third party like Michael Cohen. Again, they're painting the picture that this was not a run-of-the-mill hush money situation. Meanwhile, as Davidson's testimony is unfolding on Tuesday, a 5-judge panel at the New York Appeals Court denied Trump's request to stay this active trial pending some appeals Trump filed various pretrial rulings. For example, Trump's team is appealing Judge Marchand's decision not to recuse himself from this active trial. And so Trump requested that the appellate court rule that this trial should be halted until they make a ruling on those appeals. It's another delay tactic, and the appellate court denied the request. That all happened Tuesday while this testimony was unfolding in the Manhattan courtroom in this trial. During that time, Davidson also reviewed a series of text messages between him and National Enquirer editor Dylan Howard, again to establish the agreement reached between Stormy Daniels and the excessive back and forth with getting payment from Cohen, which was apparently very hard, and he always seemed like a very frantic, pants-on-fire guy, as Davidson testified about Michael Cohen. And as court wrapped for the day, Trump headed out to address the gaggle of reporters stationed outside the Manhattan courthouse, once again complaining about the gag order against him before heading home for the day, tucking himself into bed for the night. On Wednesday, there was no court, and so Trump used the day to hit the campaign trail, which he's not really been able to do because it's hard to campaign for president when you're also on trial for being a criminal, allegedly. But he took the advantage of the day on Wednesday, headed to Waukesha, Wisconsin, and Freeland, Michigan, held his first rallies since the start of this trial. Busy guy, busy guy. Then we get to Thursday, back in court. Thursday began with a separate hearing regarding 4 more gag order violations that the prosecution is alleging against Trump. Like, the man cannot shut the fuck up. And that seems to be a problem. And they involve comments that he made about Michael Cohen in the court hallway, comments about the judge on a phone interview, comments about Cohen to an ABC affiliate, and comments at a press event about trial witness David Pecker. Trump's team complained that the gag order was getting in the way of Trump's campaign, to which the judge responded that nothing bars Trump from commenting or responding to attacks from Joe Biden. It's really just about Trump not being allowed to refer to witnesses or the jury in this trial. It's really not that deep. Trump's attorneys didn't agree, though, and they brought 500 exhibits just for this little half-hour gag order hearing. They mostly involved media comments and attacks on Trump's, which his team claimed that barred him from responding to, which isn't fair because he's trying to run for president. And the judge responded by saying, no one's forcing Trump to talk to the press about this trial. He doesn't have to stop and shoot the shit with them every time he leaves the courtroom, okay? And the defense brought up various social media posts by Cohen attacking Trump, and the judge eventually was like, listen, you've made your point. Wrap it up. And the judge said he would issue a decision on the new gag order violations at a later time. In the meantime, it was time for Keith Davidson, attorney to Karen McDougal, Stormy Daniels, and people trying to sell celebrity sex tapes everywhere to come back to the stand. On Thursday, Davidson confirmed that he did in fact receive the wired funds from the fake LLC that Cohen set up. So again, we're just connecting the dots. And he walked through the final agreement between Stormy Daniels and Trump. The agreement used pseudonyms Peggy Peterson for Stormy and David Dennison for Trump. Davidson confirmed that Michael Cohen accepted service of the document on behalf of David Dennison, who he understood to be Donald Trump. Again, this is all evidence to corroborate their story, and it's helpful to have this physical and witness evidence come in now because it'll back up the story of their star witness, Michael Cohen, which is necessary because he's a convicted perjurer, okay? Davidson also testified that he was paid $10,000 for his role in this Stormy Daniels deal, which, like, honestly, not enough money given this headache that has resulted from it. And Davidson then testified about the Wall Street Journal leak of the Karen McDougal story on November 4th, just 4 days before the election. He testified that Cohen was very upset about the timing specifically of the article, again, because according to the prosecution, silencing these women was part of a scheme to influence the outcome of the election. He also said that Cohen said that Trump himself was very upset about the timing. Again, could be indicating that Trump knew this was all going down. Then on the night of the election, Davidson testified as the results were coming in that indicated Trump would be the next president of the United States. Keith Davidson texted National Enquirer editor Dylan Howard saying, "What have we done?" To which Howard responded, "Oh my God." So clearly they understood the role that these stories played in Trump's campaign, or would have played had they gotten out. They understood the role of that. After the election, Davidson testified about writing statements on behalf of Daniels, denying the allegations that there was an affair per the agreement he had made with Cohen, though he pushed back on calling it a hush money agreement and said it was just a settlement, okay? He took offense to that. However, despite the settlement, Stormy Daniels eventually made an appearance on Jimmy Kimmel and wanted to be more public about her affair because she saw it as a way to reinvigorate her career, according to Davidson. So he was kind of straddling an uncomfortable line. Keep his client happy, who wants to shop her story and speak her truth and have a career. And also he had to make sure she stayed in line with that hush money agreement. So there were some statements that she made at the time that the prosecution in this trial was like, would you say that this was an accurate statement? To say that they were not in a romantic and or sexual relationship. And Davidson was like, well, technically I would say that that is accurate because no one ever said it was romantic or a relationship, which is just real classic lawyer semantics bullshit to get around an agreement. Davidson testified that Cohen was apparently freaking the fuck out about Stormy's decision to go public or to insinuate things about her affair with Donald Trump. And he was texting Davidson about it nonstop, threatening to sue Daniels for violating the agreement. And after painting the picture that Cohen was obsessive about controlling the Stormy Daniels story to protect his client, the prosecution ended their questioning and the defense had its turn to ask questions. And the defense questioned Davidson on his knowledge of extortion law and brought up an investigation into Davidson back in 2012 in connection with an alleged extortion situation involving Hulk Hogan. Basically, they're trying to paint the picture that Davidson's hands are dirty. He was merely a grifter taking advantage of the situation, which I don't know that they're going to get too far with that argument. I mean, you could call all lawyers grifters with that logic, and maybe you would, but it was a settlement, not an extortion. Is every NDA extortion? Don't say this or else. Maybe, but that's just showbiz, baby. The defense also asked Davidson questions about past clients, and when he repeatedly answered that he didn't recall, the defense used that as an opportunity to question whether his memory is a little fuzzy. This is a defense tactic. Again, they just have to poke holes in the story. They don't have to present their own theory of the case. So they can do this using a throw spaghetti at the wall method. Let's see if we can question his credibility, his ability to recall things, anything that might make the jury doubt what he's saying. At one point during the trial on Thursday afternoon, Trump's attorneys approached the judge with a pile of news articles separately and asked the judge to look over them to confirm whether or not Trump could post about them or if they would violate the gag order, to which the judge was like, I'm not fucking looking over all of this shit. Not verbatim, but that's what he meant. He said, if in doubt, steer clear. And in response to accusations that he was falling asleep in court, Trump posted on Truth Social, contrary to the fake news media, I don't fall asleep during the crooked DA's witch hunt, especially not today. I simply close my beautiful blue eyes, sometimes listen intensely, and take it all in. And I know I shouldn't be surprised by the absolute batshit stuff that he posts, but it never ceases to amaze me. Anyway, next up on the witness stand, after roughly 6 hours of questioning of Keith Davidson, We had Douglas Dowse, a records custodian, another records custodian for the Manhattan DA's office, who was assigned to analyze Michael Cohen's phones as part of the Trump investigation. So he's there to enter whatever was found on those phones into evidence, and this included large batches of text messages. They also entered a recording into evidence in which Trump can be heard, and then Cohen can be heard saying that he needed to open up a company, and he had spoken with Trump's CFO, 𝗬𝗠𝗠𝗡𝗏𝗧𝗏, about how to set the whole thing up. And you can't hear Trump super clearly, but as Cohen is discussing the payoff to Stormy Daniels, you can hear Trump suggest cash, to which Cohen responds, no, 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 I'll handle it, which makes it pretty clear that Trump knew what was going on and in fact even suggested cash, something that can't be traced very easily. Like, this is not the reaction of someone who doesn't know about the Stormy Daniels payment. He would have said, what are you talking about otherwise? And on cross-examining this DA's office records guy, the defense tried to bring in to question the integrity of digital evidence generally, how it could be difficult to tell the integrity of the data. Again, they're just trying to poke holes into, like, is there any doubt that this is actually real? And then the day ended kind of abruptly during the cross-examination of Dowse, this records guy, to continue on Friday morning, which is exactly what happened. Friday morning, Dowse back on the stand for cross-exam. The defense pointed out that the recording that they had played the day before had ended abruptly, that there were gaps in the chain of custody of the phone, eventually just saying, we're just going to have to take Michael Cohen's word for it, aren't we? To which Dowse replied, yeah. Again, trying to put into doubt into the minds of jurors as to the veracity of the testimony of every single witness. That's all they have to do. They're just poking holes. So that was very brief. Next on the stand was a paralegal from the Manhattan District Attorney's Office, Georgia Longstreet, who has reviewed publicly available records relevant to the case, including Trump's social media accounts, for the last year and a half. Can you imagine just staring at his social media for 18 months? Though I guess she at least got paid for it, unlike the rest of us. So she was just there to verify his social media accounts. Again, verification of records. So she was only there for a little bit. Then we had Hope Hicks, former Trump advisor, and at one point, one of his closest aides. She was his press secretary, and she spoke very highly of Trump, saying he's a very good multitasker, a very hard worker, which sounds like a first grader's report card, but sure, go off. She described how she went from managing communications for the Trump organization to being the press secretary for the Trump campaign. Because Trump was basically like, hey, you know communication, come with me to Iowa. She was like, okay. And she confirmed that the Trump campaign media strategy was just do whatever Trump says, just follow Trump. They were just following his lead. So there just wasn't strategy. It was just whatever Trump says. She also testified that Trump regularly called David Pecker to praise him for negative stories about his political rivals. And she confirmed that news of the Access Hollywood tape really shook the campaign, and she knew that it would be bad for their work on his campaign. Again, confirming these allegations were bad for the campaign. They all knew it, and that's why they were trying to suppress them. She also asked Cohen to seek out other tapes, again, to prevent the campaign from being blindsided and damaged from these allegations. Again, prosecution is adding the building blocks, showing that all of this was a larger scheme to prevent information from getting to the public and affecting the outcome of the 2016 election. Everyone knew it. Everyone was working towards that. She also tried to suppress the Karen McDougal story from being published by the Wall Street Journal. Again, that came out 4 days prior to the election, hoping, in fact, that Jared Kushner could use his ties with Rupert Murdoch, again, because she knew it would be bad for the election. She then said that Trump told her to deny the claims by McDougal and Daniels, that there was never any affair and that they had no knowledge of any catch-and-kill agreement between McDougal and the National Enquirer. Again, because they knew it was bad for the campaign to admit that they had done any of it. Then when cross-examination started, when the defense stood up, the judge had to call a brief recess because Hope Hicks began crying on the stand. And she had said from the beginning that she was really nervous. And after court came back into session, Trump's lawyer questioned Hicks about Cohen, and she conceded that he sometimes went rogue in his service to Trump and that Cohen wasn't officially a part of his campaign. And this is the defense attempt to distance Cohen from Trump and make it seem like he was acting as a lone wolf, not at Trump's behest. And after about 20 minutes of cross-exam, the defense finished up and the judge ended court for the week. And just before court ended, however, the judge ruled that prosecutors would not be allowed to bring up Trump's new contempt charges related to the gag order should Trump decide to testify on his own behalf. We still don't know if that's going to happen, though. Again, Trump has said that he will. I hope that he will, because that sounds fun. So that wraps up another week of witness testimony here at this trial. More witnesses to come next week, of course, and including Michael Cohen, though we don't know exactly when he will come, what the order of witnesses is yet. So we'll just have to stay tuned to find out what will happen next week. But you can join me on Patreon for even more updates, and I'll see you next Saturday for another Trump trial recap. Thanks so much for being here. Have a good day. Bye-bye.